Hi. I'm making this video at this time uh, because I'm having some health problems and it needs to be said, it needs to be done. My son's mother and I just left the sheriff's department here in Phoenix, where we were treated like criminals. We went there to try to get more information and hopefully clarity on why the sheriff's department investigated our son's accident the way they did. Instead, we were put in a locked room and videotaped without our knowledge. Instead of being prepared to give us answers, all they wanted to do was sit and get information from us. Their intent clearly was not to clarify their actions, either the sheriff's actions, the investigating officer that investigated the accident, or the internal affairs that supposedly also investigated it. What I brought to his attention was the fact that their own records show that the driver was speeding, that the driver didn't have his headlights on, that the driver did not have his seatbelt on. Their own evidence showed that they were inconsistent with their narrative as to the accident. They staged PJ's bike on the north side of the street in the westbound lane, but the first sheriff on the scene indicated that the bike was on the south side and in the eastbound lane. And the reason that's significant is because they're claiming that PJ was in the middle of the road, but yet the pictures, as you could see in the other videos, show that PJ was on the shoulder by the fog line when he was hit. The car, the bumper, clearly shows that PJ was hit on the passenger side, yet the sheriff say that PJ was hit on the driver's side. Clearly, they've been very inconsistent. And the question of whether or not there was collusion comes up in that the family was allowed access to the scene. They were allowed to go through the vehicle, taking whatever they wanted, and there is no indication that that vehicle was searched. There's also a question of a black briefcase that was shown at the scene. These things are in pictures. We have evidence of that. Also, that the driver was allowed to leave the scene in a vehicle that later returned to the vehicle, and when the sheriff was to interview him, he was in the vehicle of a friend at the far end of the marked off crime scene. Why? Why was it so important to make PJ guilty of being in the middle of the road? The driver, the evidence shows that he was never drug tested. He refused to go to the hospital. There was law enforcement there that appeared to be family or friends, because when they got there, they went right over to him to console him. All this is happening while PJ is laying in the road fighting for his life. And to continue this problem, PJ gets to the hospital. They didn't find a wallet, so they identified him as being other than American. And it's our belief that they thought he was an illegal alien because there was no APHIS hit when they checked his fingerprint. PJ was O positive, making him a universal donor. And that is exactly what they intended to do by not treating him. The record indicate that PJ, when he arrived in the emergency room at 9:28, he wasn't given sedation, he wasn't given pain medication. They didn't do what was called a rapid sequence induction. They inserted the tube without those things, and his vital signs went through the roof. His heart rate went from 65 to 165. His blood pressure went up over 200. When he got there, his vital signs were a high norm. It indicated that, in the record, that he was breathing spontaneously also. Then the record indicates that at 10:35 there is a record of another intubation. At this intubation, there's an indication that drugs were given consistent with a rapid sequence induction. That included fentanyl and succinylcholine, along with vicromium. Prior to that, they also gave him fentanyl. Giving fentanyl before this procedure is consistent with a rapid sequence induction. However, this is only indicated at 10:35 and not at 9:28, which is indicated as the first intubation. You don't do a second intubation if the first one is successful. Clearly, it wasn't. Clearly, they put PJ in more distress. That's evident in the records by the fact that his heart rate jumped up, his blood pressure also jumped up, those things being indicative of rises in intracranial pressure. That's where the secondary injury occurs. And that's what happened in PJ's case, where there was a loss of chance. The records also indicate that he was given mannitol, which reduces intracranial pressure. But that was only done after a call from a physician in the emergency room to the neurosurgery department. However, the records would later indicate that he was seen by a neurosurgeon, but yet that neurosurgeon's record dictation takes place at 23:55. That's 5 to 10 minutes before midnight. Remember, PJ arrived at the emergency room at 9:15. I picked up partial records on the 10th of November. Again, PJ's accident took place on November 3rd. But because of concerns that I had that PJ was not treated, his head injury was not treated, I went and got partial records. When I got those partial records, it indicated that only after PJ was intubated and only after a CT scan was done was he evaluated by his neurosurgeon. However, the records were altered to try to indicate that he was seen by this neurosurgeon at 21:23. That's 9:23 p.m. If PJ was seen at 9:23 p.m. and exhibited signs of raised intracranial pressure because of his dilated pupils and because of the corticate posturing, then that neurosurgeon had to know that the most important thing was to address the intracranial pressure. And it was him that should have ordered the mannitol, but he didn't. The record was later changed to try to indicate, stating that he was seen multiple times, both in the trauma bay and in the ICU. However, that added note did not indicate an addendum or a modification of the record. No, they altered the record illegally. Later on, after getting the records, I would learn that PJ also had a lacerated spleen. Keep in mind that the major thing was the head injury. But a lacerated spleen would cause bleeding. We weren't informed of that. I had to find that out on my own. PJ's head injury, when the CT scan was done, indicated that he had a 15 millimeter subdural hematoma with a 9 millimeter midline shift, 9 to 10. All the research that I've been able to do, the Brain Trauma Foundation, the American Association for Neurosurgeons, indicate that in spite of the Glasgow Coma score, this individual should be rushed into surgery in order to relieve what's called a mass lesion, that being the accumulation of blood in the skull, which is a closed off area, and that causes shifting of the brain. However, what this neurosurgeon, again, his note took place at 2350, 2355. If he had seen PJ before at 9:23, his note would indicate or start off seeing PJ before he was intubated, but yet his note starts off, patient is intubated, and a CT scan was done, then patient was emergently evaluated by him. Now, if he received the neuromuscular blocking agents at 10:35, usually it takes up to 60 minutes before a full neurological exam can be done. That would take the time from 10:35 to 11:35, being more consistent with the fact that his note is not dictated until 10 minutes to 12. Later on, when I was notified the next day, I noted that PJ didn't have on a cervical collar, nor had there been any attempt to relieve the intracranial pressure. The records also indicated, both in a 9:30 note, at a 12:30 note, and a 3 o'clock in the morning note, that donor network was notified. They made no attempt to preserve the quality of life of PJ or his life in general. They intended to use him as an organ donor. They didn't expect any family to be involved or to come forward so that they could do what they wanted to do. From the very beginning, I had problems with the ICU neurosurgical team, the lead. That was a Dr. Carrick. When I looked at the records and I found that they only did one CT scan. They didn't do the rapid sequence induction. At midnight is when they gave him something as a sedation, propofol. The following morning, they would start him on fentanyl. But if they believed that he had no neurological response and no brainstem activity, there would have been no point to that. So, difficulty that I was having with this Dr. Carrick was the fact that they never did an EEG, that's an electroencephalograph, to determine if he had any brain activity. They never did that. They only did one CT scan, so they were not concerned about whether or not it got better or worse. And I spoke to a radiologist out of Milwaukee that indicated that in itself is suspicious. They would normally, every half hour or every hour, repeat the CT scan. This neurosurgeon minimized the impact of the findings of the first CT scan, indicating that Paul had a 9mm hematoma and a 4mm midline shift. However, the criteria for going directly to surgery was 15 and 10, and that's what PJ was. So there's no doubt that PJ should have went directly into surgery to have a DC, either by drilling a hole in his skull to relieve the pressure, that being the blood accumulating, or removing part of his skull to allow his brain to swell and to avoid what's called herniation. So as we continued the process, prayers and vigils, spending the night there, I noticed that PJ's urine was extremely concentrated. When I brought this up to this Dr. Carrick, she removed his catheter so that this could never be observed again. What we were concerned about was that he was not being properly hydrated, and the records would eventually show that that is exactly the case. Nor was he given proper nutrition, which, again, by the Brain Trauma Foundation, American Association of Neurosurgeons, Nutrition is important in the early phases of recovering from a traumatic brain injury. On the 12th, we got a phone call. Apparently, they had been talking to a young lady that Marzi, my son's mother, and I didn't know. She stated she was a girlfriend. Well, I knew that PJ had went to stay with the girl, but I had never met her. However, that night after we left, she decided to stay. This Dr. Carrot violated the HIPAA laws by having a conversation with this individual in which she determined, based upon her conversation with this girl, to make PJ a do not resuscitate. We get a call the following morning, her telling us that that's what they're going to do. Not asking us, telling us. So we rush to the hospital and have a conversation with this person. Again, this is before we had an opportunity to look up the law. What they did was against the law. As surrogate decision makers, we have the right to determine whether or not to make him a DNR or not. Me having a healthcare background, I had some idea of what we were hoping for. And so it's not like we couldn't make an informed decision. But we wanted to hold on. We wanted to pray on it. And we thought that they were working with us. We would later find out that they were working against us. Not only to cover up the fact that they didn't treat him properly to begin with, but also to rush the process of making him an organ donor. Keep in mind, in the beginning, once they called these individuals at the organ donation organization, then people were put on standby, and they were aware of this. I don't think they had any concern about the black man's life that was fading away. Their concern was for the possible recipients that I have a feeling that those people were identified. Again, he was O positive. So he was a universal donor. So besides the HIPAA violation, taking away our surrogate decision-making rights, we couldn't go on with this doctor being taking care of our son. Care was switched to a second team. But when that second team came in, immediately they increased his tube feeding, increased his hydration. What the first team wanted to call neurostorming, they did tests and determined that he had a what's called a VAP, ventilator-acquired pneumonia. That's why he had the chills, tachycardia, which is the increased heart rate, and blood pressure, and the sweats. My research also indicated that that's the first thing you have to look at before claiming that the individual is neurostorming. As a matter of fact, some research I found indicated that neurostorming was a sign of healing. But on that same subject, the records indicate that there was a nurse practitioner on duty. Now, I would later get the flow sheets that show his heart rate and his blood pressure and his respirations. Again, his respirations were always higher than the ventilator for the most part. There were times when he was sedated, when the ventilator, when the rate was equivalent to the ventilator setting of 14. However, on the 10th, this nurse practitioner gave PJ a drug called propranolol. Now what followed is, and this is in the note, that his heart rate went down to the 20s. That per the nurse practitioner. The team leader, this Dr. Carrick, would later say his heart rate went down to the 40s. But she would also indicate that he had a stroke and that he had cardiac edema. Well, these things took place because of that nurse practitioner ordering him propranolol. He had never received that prior to that point. And it's my belief that it was important to them that PJ died when we were not there. And making PJ a do not resuscitate was essential in the process of getting his organs. Subtle hints as to the hopelessness of PJ's case would be used to lean us towards trying to make a good situation out of a bad one, because we're constantly told how hopeless it was. We didn't know that he started showing improvements. Again, the neurosurgeon said no brainstem activity, no neurological function. Well, if he's brain dead, say brain dead. If you believe he's brain dead, do the test with the electroencephalograph to determine if he's brain dead. But they didn't want those tests because those tests would not fit his narrative, this neurosurgeon or this Dr. Carey. On the 28th of November, I asked them to do a breathing test to determine if he could breathe on his own when he wasn't on sedation. The results were after 10 minutes, he continued to breathe on his own. That same doctor would later say, I was asked, quote, I was asked if I think that PJ would die within 90 minutes if removed from the ventilator. The doctor stated, no, I believe he would live much longer than that. The following day, on the 29th, there was another breathing test. And after 10 minutes, it's called no DSAT, meaning there was no change in his oxygen level when they disconnected him from the ventilator. Now, again, our thought is that's what they would do at the end. Remove him, disconnect him from the ventilator, so that if he continued to breathe on his own, we would put him in a skilled nursing facility. If he didn't, we would allow him to be an organ donor. I asked the individual from the organ donation place, what medications would PJ be on if we were to sign the papers? She indicated that the only other drug that he would receive is heparin. We would later find out that that was a lie. On December 1st, the day that he was going to be removed from the ventilator, I got a call from this doctor. He was scheduled to be removed from the ventilator at 8 p.m. Around 4 p.m., I got a call from this individual from the organ donation place, Donor Network of Arizona. She asked me if we could change the time from 8 p.m. to 7 p.m. to facilitate an organ donor surgeon. And in the back of my mind, I'm wondering what makes her so sure that he would die in that time. We would later find out. According to the records, that morning there was an order placed for fentanyl, IV push, morphine, IV push, Ativan, IV push, and then later there were additional orders that were given for morphine, Ativan, and potassium chloride. He received a large dose of the potassium chloride even though at 4 p.m. his potassium level was low. Now, if you're expecting this person to expire in 3 hours and become an organ donor, what would be the significance of giving him potassium chloride when it is non-therapeutic and non-related to the process of taking him off the ventilator? Later, we would receive a letter, an unsolicited letter from the hospital, stating that PJ didn't receive anything that was IV push. But yet the records clearly indicate that was not so. According to the letter, PJ died at 7:40 p.m. They stated that's the time that he was taken into the operating room. Well, he wasn't taken into the operating room until he was deceased. Records would later show that he received morphine at 8:05 p.m. and at 8:25 p.m. he received a blood transfusion. Now, how does that happen if you have no heartbeat? Two of the records also indicate that there were two drugs, morphine and Ativan, that were not discontinued until 2 o'clock in the morning, or 1:19 in the morning. All other meds or orders were discontinued at 7:35 p.m. Why? When you consider those orders and you consider the time that they wrote in the letter that PJ expired, this would lead us to believe that there is a possibility that PJ was revived when he got into the operating room in order to try to keep viable more organs. I'm talking about what the record says. If you send me a letter and tell me that my son died at 7:40 p.m., yet there are orders after you said that there were no orders that were IV push, and the 805 morphine, 4 milligrams, was given at 8:05, and that was a bolus, which is the same as an IV push. Something isn't matching up. If you got orders that are not discontinued until 1:19 the following morning, when all other orders were discontinued, why? You would think that after his heart stopped, you could take all lines out of him, all IV lines out, indicating a consistent time in which those therapies were discontinued. But that's not what the record says. It's hard to say how much we've been through, I've been through. This has been beyond comprehension. We had hired a lawyer for medical malpractice and wrongful death, only to find out that he gave us a personal injury agreement, which he couldn't legally do, entitling him to 33% of my underinsured motorists. However, he waited until PJ was in the morgue for 6 days to tell us that they don't do medical malpractice, and there was no indication of that prior to that. As a matter of fact, their website indicated medical malpractice. However, after the fact, we were unable to get an attorney to take PJ's case because they would only be getting 15%, whereas had they been taking the case from the beginning, they would have received 30 to 33%. That has kept us from getting any legal representation in terms of the wrongful death. And it is our belief that that represented legal malpractice. I took that same issue to the State Bar of Arizona, along with some other inconsistencies in the representation by this attorney. They would later take the most insignificant of concerns and make a decision on it, not making a decision on the fact that they couldn't give us a personal injury agreement because PJ wasn't incompetent. That type of an agreement can only be if the person is incompetent and I'm the power of attorney or a spouse. So we lost out on any legal remedy. We lost out on any legal remedy concerning the sheriff's department and what the collusion, the staging, the screwed up investigation. There's more to it there. But we'll never find it if we're treated like criminals the way we were today. And this is my 5th time speaking to them. When it came time to ask him about, look, if you messed up the investigation, well, do the right thing. Do right with the investigation and forward it to the county attorney. The county attorney wouldn't even come out and talk to us. We wouldn't return our phone calls. But they indicated after speaking to a receptionist, what have you, that the only way that they would consider a case is if the sheriff department sent it to them. Well, that was our question today. Do the right thing and send it to the county attorney. Now, we'd like to believe that the right thing would be done with that. But I have to tell you that It's my belief that probably what would have happened would have been a covering up and a covering for the sheriff's department. There is a clear circling of the wagons here with the racism. It has been the most oppressive thing I've ever experienced. It has affected my health, my well-being, and considering the ruptured appendix, the misdiagnosis, the failed surgery, and what could be internal bleeding that I might be experiencing now, I've put everything I have into this, and we get no response. Whether it's from the media, the One Black newspaper, or the local churches. This is not made up. We have the evidence, we have the records. But in this circle, nobody cares. And we're running out of options. So the only thing I felt that we could do, or I could do, was to make this video, the last video. I hope someone will understand what we're going through, how wrong this is, how unacceptable this is, and step forward and help us. Thanks for your time. God bless.